Hello, government students. This is Elizabeth Floyd, your professor, and I'm giving a lecture now on civil liberties for Learning Module 9. I'll be using the same PowerPoint for Learning Module 10, which is why the slide you see right now has civil liberties and civil rights. For this first part, though, we're just focusing on civil liberties. So by the completion of Learning Module 9, you should be able to explain the difference between civil liberties and civil rights. Explain the arguments of Federalists and Anti-Federalists regarding the Bill of Rights. Identify the civil liberties that are protected in the Constitution, their historical context, and the basic principles of current law regarding their protection. And here are a few of the terms and concepts I'll be covering in this lecture. So we start off talking about the difference between civil liberties and civil rights. People often use those two terms interchangeably, but they are not the same thing, and I'll explain the difference. Civil liberties are about the freedom of individuals, and civil rights are collective rights. So as far as civil liberties go, we're talking about the freedom that an individual ought to have in a free country. You probably would think of these as the unalienable rights or the natural rights that are kind of referred to loosely in the Declaration of Independence, but then they're listed in the Constitution. Several are enumerated in the original Constitution. Others are enumerated in the Bill of Rights, and then some additional ones came through amendments. But these are the liberties that were considered by the founding generation as the most under threat at that time. Not they were never considered to be a complete list of all of the natural rights that a person may have. And the Ninth Amendment actually says that this is not intended to be a exhaustive list of all the civil liberties that a person is entitled to. But it was an effort to identify the ones that the people of the founding fathers generation felt were most under threat by government. Um, there are also unenumerated civil liberties that have just been recognized over the course of time by the court system, but we're just focusing in this lecture for the enumerated ones. Um, Keep in mind that it's not just citizens who have their liberties protected. These are considered natural rights. It's not something that comes with citizenship. It comes with simply being a human and living in a free country. So, what does it mean to be free in any society? Those are the liberties that we're talking about. There are civil liberties. We also sometimes call them fundamental rights. So thinking of them as what is fundamental to freedom? What does it mean to be a person living in a free society? Those are your civil liberties. Civil rights, again, are collective rights, and they are the obligation of government to treat people equally and not on the basis of any particular grouping or category, such as race or ethnicity or gender. They're often called equal protection rights because we're talking about the obligation of the government to treat groups of people equally. So, like I said, we're only going to focus on civil liberties in this particular lecture in this Learning Module 9, and also within that, just the enumerated ones. And the enumerated civil liberties can be found in the original Constitution, not just the Bill of Rights. The Constitution, if you recall, was written to create and limit the powers of the national government. And it did not have a Bill of Rights when it was submitted to the states for ratification, but it did limit the power of the national and state governments in certain specific ways. So, looking now just at the original Constitution, we'll see limitations on the national government in Article 1, Section 9, where it protects people or guarantees the right of a person to assert petitions for habeas corpus. This is the right of a person who's been convicted, who's been incarcerated or in custody by government to challenge their confinement, to be heard by an impartial judge, and that impartial judge determines whether their detention is constitutional or valid or not. That right to petition for writ of habeas corpus is protected in the original Constitution. Another one is a bill of attainder. This is a bill of attainder is when Congress might write a law that sort of defines a person as guilty of having committed an offense. So, sort of like when Congress attempts to act like a court and hold someone liable, impose fine or punishment on someone through passing a law. That law would be called a bill of attainder, and that would be a violation of the separation of powers. So the Constitution limits the national government's ability to do that, to protect an individual's right to be tried in a court before a jury. The Constitution protects individuals against ex post facto laws. These are laws that punish a person for something that was legal at the time they did it. So it's a ban on retroactive laws. Laws you can't be punished for something if a behavior was legal when you did it, you can't be punished if that same behavior later becomes a crime. They can't retroactively prosecute you for that behavior. So no retroactive laws. That's an ex post facto law. And in the original Constitution, individuals are guaranteed a right to a jury trial in criminal cases. That's actually in Article 3. But these are all limitations on the national government's power, and it is protecting the civil liberties of individuals in the original Constitution, not in the Bill of Rights. But before we even had a Bill of Rights, there were these protections for us. The original Constitution also places some limits on state governments. Example might be that there's a section, I don't recall exactly where, that limits state government's powers, just requiring them to extend the same privileges and immunities to the citizens of other states. For example, South Carolina would have to extend the same privileges and rights to people from out of state. You might think of this if you are a non-resident of South Carolina, but you're here in Greenwood and attending school at Lander. Even though you're not a citizen in South Carolina, the state of South Carolina has to give you the same privileges and immunities it would give to a citizen of South Carolina. And that's just an example. There are other limitations on state government power that provide protection for civil liberties with respect to state governments. But the best known source of our enumerated civil liberties is the Bill of Rights. This is what you're probably most familiar with. There are also civil liberties that are protected by the court system through the application of something called substantive due process. And that is a topic I will go into with our next lecture. So we won't get to that. But this slide is really just an effort to help you kind of fix in your mind the foundation of where you can find protection of civil liberties. The original Constitution, the Bill of Rights, and decisions of the U.S. Supreme Court. All three are sources of protection for civil liberties. But we're going to go and spend the rest of this lecture just focusing on the Bill of Rights. But first, we got to talk about how we got to have them. As I said, they were not in the original Constitution. They came about a couple years later as a result of the ratification debates. If you recall, the ratification debates were debates between a group of people known as the Federalists and a group of people we now call anti-Federalists. The Federalists were largely responsible for having the Constitution, for writing it, and they chose not to have a Bill of Rights. They did not believe a Bill of Rights was necessary. They were satisfied that the original Constitution did enough to limit the power of government. So that's really one of their main justifications is that we had just established in the Constitution a limited government. If the government was not given the power to infringe on a liberty, then it couldn't. And the judicial branch would protect that liberty simply by holding that government had exceeded its authority, exceeded the limited powers granted to it by the Constitution. For Federalists, that was enough protection. They were also concerned about it being dangerous to try to list civil liberties. It might suggest that those were the only civil liberties that the American government was obligated to respect. So they didn't want to. They didn't want to create that any sort of argument that their list was all there were. They thought that was risky. So that was a reason not to try to list them, not have a Bill of Rights for that fear. Anti-Federalists, Anti-Federalists, though, as you might expect, thought a Bill of Rights was absolutely necessary. They were not at all satisfied with the original Constitution, feeling that particularly the elastic clause, the necessary and proper clause in Article 1, they felt like that was too open-ended. It gave an opening for Congress to exceed and abuse its powers that were provided in the Constitution. So the Bill of Rights then was a sticking point, and there were two in particular states, Virginia and New York, who refused to ratify the Constitution without a Bill of Rights. They just wouldn't agree to it. And once New York and Virginia took that position, additional states did as well. And so it became something that the Founding Fathers absolutely had to do. James Madison promised his constituents there in Virginia that he would, first thing in Congress, first action he would take would be to draft a Bill of Rights. He followed through on that process, and that's how we came to have them. He modeled his Bill of Rights on the sort of the Virginia's version of Bill of Rights from the Virginia Constitution, and used that as a model for drafting a proposed Bill of Rights. He presented them in Congress, the very first Congress of the United States. They whittled it down to 12 amendments and then sent those 12 amendments out to the various states for ratification. But in the end, only 10 were ratified, and that's where we got the first 10 amendments of the Constitution that we now call the Bill of Rights. So I have one of your learning module assignments for this learning module is to kind of take a stab at it yourself and write your own Bill of Rights. You don't have to model it or use our current Bill of Rights as a go-by. You can write your own, but I thought it would be a fun and interesting activity, help you kind of see how hard it is to identify what civil liberties are so essential that they ought to be enumerated. But now what I'm going to do is show a video here that is going to introduce, it's going to talk a little bit about the ratification debates, but then it's going to kind of give a quick overview of the Bill of Rights.
Taking them away. But what specific rights are covered by the Constitution? And how did those guarantees get there in the first one? Historian Rick Beeman knows something about this. We're discussing essential human rights the way the Founding Fathers would have done it, over a beer at Philadelphia's City Tavern. So this is City Tavern. This is very nice. Cheers. Oh yeah, that puts me in the mind.
And I think it probably put them in a much better frame of mind. They'd spent, from 10 o'clock in the morning till 3:30 or 4 in the State House. Then they came over here and relaxed, but they also kept talking.
So among the things they didn't include, despite all the conviviality, was the Bill of Rights in the original Constitution. Well, why didn't they? It's kind of natural.
So they had lots of excuses. States already had their bills of rights, so it would be redundant.
Right.
What if we leave out a few key rights? That would be dangerous.
Right.
But the real reason, I think, is they wanted to go home. They thought it might take another couple of months.
So you're saying that the reason that we don't have, or we didn't have a Bill of Rights in the original Constitution was that everybody was tired and grumpy and wanted to go home?
Well, I honestly, Peter, I think that's the main reason. And once the Constitution went out to the public for ratification, they learned very quickly that they'd made a mistake.
After the delegates signed the draft Constitution, it had to go out to the 13 states for ratification. But when the states started looking at it, there was a whole new round of debates with meetings and speeches and newspaper articles arguing pro and con, back and forth. Good patriots like Patrick Henry of Virginia, that's the guy who said, "Give me liberty or give me death," were afraid that the new Constitution, with its strong central government, would lead to the death of liberty. What was missing was a Bill of Rights to protect individual freedom. But here was the deal. The document couldn't be changed or amended by any state. They had to vote up or down, yea or nay, to approve the whole thing and make the Constitution the law of the land. There were all these states that said, okay, we'd be willing to do this if there were a Bill of Rights. And the pro-Constitution forces said, okay, as soon as you give us a Congress, the first thing we'll do is give you a Bill of Rights. Is that more or less right?
Most of the pro-Constitution folks said that.
So the ratification was a popular vote in each state?
It was as popular a vote as had ever occurred anywhere in the world. That didn't mean that women could vote or that slaves could vote, but literally all free adult males in most states, black or white,
Really?
could vote. It didn't matter whether you owned property. This really was a vote among we the people.
How did the specific rights that we now think of as the Bill of Rights, how were they conceived? Where do they come from?
So, the Constitution is finally ratified.
Right.
And really, all of the rights come out of British encroachments on American liberties during the decade or more leading up to the Revolution.
And there they are, the Bill of Rights. All 10 amendments are framed as limits on the central government. They're nearly all written in negative terms. Congress shall make no law. Congress shall not. Instead of making promises, we set boundaries. Right at the start, the First Amendment includes the big three freedoms: freedom of religion, speech, and the press. Next comes the second, with its well-regulated militia, or the right to keep and bear arms, depending on how you feel about that one. The Third Amendment is entirely devoted to protecting you from having government troops take up residence in your home. Can you imagine having redcoats coming in and raiding their refrigerator at 3 a.m? The Fourth Amendment secures our freedom from unreasonable search and seizure. The Fifth protects you from being tried twice for the same charge, or from being forced to testify against yourself. That's the familiar right to remain silent, the one that we invoke when we take the Fifth. The Sixth Amendment ensures a fair trial in criminal cases, speedy and public, and with a lawyer. The Seventh guarantees a jury trial in many civil cases. The Eighth Amendment protects against cruel and unusual punishment. Of course, what's cruel and what's unusual is left to the courts to decide. Flogging? No. Death? Maybe. Educational TV? Depends on the show. Some people worry that the importance of a list is as much what's not on it as what is on it. So the Ninth Amendment declared that just because certain rights are listed here, it doesn't mean that there are no others. And the 10th Amendment says that the powers not specifically given to the government of the Constitution are reserved to the states and the people. For the founding generation of America, the greatest threat to individual liberty was the government they were creating. So even as they created it, they limited its powers. The language.
Okay. That gives you an overview of all of the Bill of Rights. And now I'll go and, or in a minute, I'll go and talk about them individually. But first, we've got to look at how we've gotten a little bit beyond just the Bill of Rights. As they mentioned in the video, the Bill of Rights were an effort to limit the power of just the central government, the government that the people were creating. They immediately limited. They limited it by defining what powers it would have instead of suggesting that it had all power. They just specified what powers that it would have. So they weren't really focused on state governments at the time. States had their own constitutions, and those constitutions already had protection for civil liberties. So state governments weren't really the focus of concern. They weren't threatening. It was easy to hold your state government accountable because they're closer by. People knew their representatives in state government. The national government, the central government, was considered the risky endeavor at this time. But that changed, and that big change became obvious there in the Civil War. After the Civil War was over, the former Confederate states, the states who had seceded, we had every reason to believe that once they rejoined the Union and had representation in Congress again, that they would go back to their old ways of infringing on the liberties of African Americans and former slaves. So the majority in Congress at the time was a political party known as the Radical Republicans, and they proposed three amendments that we refer to now as the Reconstruction Amendments because of the time period in which they were ratified. And they were intended to protect former slaves from the former Confederate states. So the first one was the 13th Amendment, and that prohibits slavery. And that's the language I've got on the slide, what it actually says. Slavery nor involuntary servitude shall exist within the United States. It also gives Congress powers to enact laws to further the ban on slavery, the abolition. And Congress used that language, that enabling clause there in the 13th Amendment to pass some of the initial civil rights legislation that our country saw. The 14th Amendment, also a Reconstruction Amendment, did a lot of things. It's kind of a long amendment. I'll just go through a few pieces of it. Part of it defines citizenship. It says that all people born or naturalized in the United States and subject to the jurisdiction of the United States are citizens of the United States. So that effort to define what citizenship meant, it's interesting. We had never had that in our Constitution until we got the 14th Amendment. The term citizen was not defined, but we got that with the 14th Amendment. And if you recall from a prior lesson, we studied the U.S. Supreme Court decision Dred Scott versus Sanford involving a slave whose owner had taken him from a slave-owning state to a free state, a state where slavery had been abolished. And he had lived there in that free state for a few years. And so the slave, Dred Scott, filed a lawsuit to assert that he became free when he entered that free state. That challenge that he made got to the U.S. Supreme Court, and the U.S. Supreme Court said no, slaves are not citizens. Therefore, the slave could not bring his case in any court. And so it was the Dred Scott decision then became the law of the land for a time, but the 14th Amendment nullified the Dred Scott decision because it said all people born or naturalized in the U.S. are citizens. So that undid a U.S. Supreme Court decision. Here's your example of the legislature or the people, however you look at it, checking the power of the judicial branch. They amend the Constitution, and if you amend the Constitution, you can nullify a Supreme Court decision. That's what happened here. The 14th Amendment goes further in including a privileges and immunities clause. I mentioned this just a second ago when I was talking about limitations on state power that are found within the original Constitution. In the 14th Amendment, we carry that forward, and it says state governments have to treat citizens of other states the same way they treat citizens of their own state. So similar language that you would find in the original Constitution is stated here in the 14th Amendment, and it is been subject to some controversy as to what does it mean? What what does the Privileges and Immunities Clause really mean? It's open for debate. It's unsettled. 14th Amendment also includes a due process clause that echoes the Fifth Amendment. We'll study the Fifth Amendment here in a minute. Language is virtually identical, but of course, in the 14th Amendment, we're talking about due process protections against state governments. And due process has two different meanings. You can refer to the due process clause when you're looking at protections that are procedural in nature, like a person's right to have an attorney present. That's a due process right, but it's of a procedural nature. But there are also certain substantive rights that courts have identified and said, this substantive right, such as the right to marry, cannot be infringed upon by a state government, absent some compelling reason. So those are just two different types of rights that due process covers. We'll talk a bit more about substantive and procedural due process later. There is an equal protection clause in the 14th Amendment as well. It also echoes the Fifth Amendment's equal protection clause, but again, we're dealing with the state governments when we're talking about the 14th Amendment. And excuse me, I misspoke there. The Fifth Amendment actually doesn't have an equal protection clause, but it is used in a similar way than the 14th Amendment. The 15th Amendment is protection for the right to vote. And that's the last of the three Reconstruction Amendments. And it's limiting the ability of state governments to interfere with former slaves' right to vote. Now, I'm sure you all know enough about U.S. history to remember that state governments still infringed on the voting rights of African Americans for another 100 years. But the 15th Amendment includes an enabling clause, just like the 13th Amendment did. So on the authority of the 15th Amendment, Congress enacted the Voting Rights Act in 1965 that put an end to the disenfranchisement of African Americans. We continue on for a minute about extending civil liberties. You can check out the graphic here. That's going to help you understand. The Bill of Rights you see here was put in place to protect people from the actions of the central government. So you see the three branches of government represented here, and they're tied up and limited by the Bill of Rights. You have state governments over here being silly because the Bill of Rights didn't apply to them. So, hey, they don't have to worry about it. Oh, but yes, they do. With the 14th Amendment, the courts have held that this language, the Due Process Clause in the 14th Amendment, says, nor shall any state deprive any person of life, liberty, or property without due process of law. That language, according to our court system, means that even states cannot infringe on civil liberties. They don't say that as a total incorporation situation where automatically the 14th Amendment incorporates all possible civil liberties so that state governments can't interfere with them. The courts haven't interpreted it that way. That would be called total incorporation. Instead, what our federal courts have done is select specific civil liberties on a case-by-case basis and evaluated that liberty and determined whether that liberty is an aspect of due process. And if they find that it is part of the due process protections of the 14th Amendment, then it will be incorporated into that language and protected by the 14th Amendment. So that's what we know is the doctrine of selective incorporation, that case-by-case determination of whether a civil liberty is part of this due process language of the 14th Amendment. Last, keep in mind as we're going through all these civil liberties, that they only kick in, these protections only kick in when the government is doing something. It does not restrict the powers of individuals. So it's not gonna, freedom of speech, freedom of religion, those protections only kick in when the government does something to infringe upon them. Private citizens are not obligated by the Bill of Rights. So now we'll go and look at what these specific civil liberties, these enumerated civil liberties are. And I've got a transcript there, copy of the First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or the press, or of the right of the people peaceably to assemble, and to petition the government for a redress of grievances. So it's not just one right. People hear the word the 10 Amendments and assume, oh, that's protection for 10 liberties. No, it's like 26 different liberties. So there are several civil liberties packed into a single amendment. This one in particular has 6 different civil liberties, and you can categorize them in one of 3 ways: a freedom of or religious freedoms, expressive freedoms, and freedoms associated with political behavior. Those are my categories. Anyway, they are the way I categorize the 6 civil liberties in the First Amendment. So as far as religious liberties go, we have an establishment clause and a free exercise clause, those first 2. As far as expressive rights go, we have the freedom of speech and the freedom of press. And then with political behavior, we have the right to assemble and the right to petition our government for a redress of grievances. So I'm going to now move into those 6 liberties. We'll look first at the Establishment Clause. The Establishment Clause reads, Congress shall make no law respecting an establishment of religion. That particular phrase has a lot of history to it, and it comes from a broader understanding of world history and the power that the Catholic Church held in Western Europe in particular during the Middle Ages and then moving into the Enlightenment era. You don't have to really know all of world history to really understand the concepts for this class, but I want you to know sort of what the foundation was. Why did we put this in the Constitution? It was because at the time, in the late 1700s, many governments, most, if not every government, had a state-sponsored religion. For example, in England, where most of the early settlers in the New England colonies came from England, and in England, the Anglican Church was supported by the government of England. That meant taxes that the people paid in England supported the Anglican Church directly. A portion of the taxes went straight into the coffers of the church, paid for church construction, church operations, paid the salaries of the rectors and ministers of the church. So you had an obligation to fund a specific church as an English or a British citizen. And that was a big problem for many of the many English people, and that is partly what drove them to leave England in the first place. They did not agree with the tenets of the Anglican Church, so they left. And they were considered dissenting religions. They had these people formed their own religions that contradicted the tenets of the Anglican Church. Or in the case of the Catholic Church in Italy and some of the other countries where the Catholic Church was supported by the government, there were dissenting faiths, people who disagreed with those tenets. They left. They came to the New World for the purpose of escaping that sort of coerced support of religion. So that's the background of it. That's why we get to forming our own central government, and we see, well, that is the reason why people came here. We've got to provide some protection from that sort of government sponsoring or endorsing of religion. There's also a consequence of that immigration from a variety of different countries in Western Europe meant a variety of different religions. existed and were being practiced in England in the British colonies in the New World in the late 1700s. And so that variety of religious traditions gave us a pluralistic religious environment. Many different religious traditions were being practiced here. They were mostly within, the overall umbrella of Christianity. There were some Jewish people in the British colonies at the time, not a whole lot. There were some Catholics who were living in some of the colonies. Most, though, were Protestant Christians, but a variety of different denominations of Protestant Christianity. The Anglican Church, the Methodist Church, Baptist Church, Presbyterian Church, a lot of different Protestant denominations had been formed and were being practiced in the British colonies. So that pluralism coupled with the background of dissent that many of the English settlers brought with them when they came to the British colonies led our founding fathers to believe that we had to provide some sort of protection against any sort of established church. The two founding fathers you can thank for this were really Thomas Jefferson and James Madison. They had led a movement there in Virginia to separate the Anglican Church, at this time it would have been the Episcopal Church in Virginia, from the government of Virginia. And they succeeded in doing that, in passing a law that was called the Virginia Declaration of Rights. And so that principle of separating church and state that existed in Virginia was the basis for our First Amendment's Establishment Clause, that Congress shall make no law respecting an establishment of religion. We would not have a central government that directly supported any religion. In the end, the whole point, the policy, is that religion ought to be a matter of choice, of conscience, and not coercion. So coercion would be laws requiring people to attend or financially support a church. That would not be valid under the Establishment Clause. The interpretation of the Establishment Clause now takes one of three forms. You you hear the words Congress shall make no laws respecting the establishment of religion, and you might think of the saying that we have a wall of separation between church and state, hence this graphic. There is no such thing as a wall of separation between church and state in America, and there never has been. There are judges and legal scholars who believe we ought to have a strict separation between church and state. Some of those legal scholars were Supreme Court justices, and they did lead a couple of decisions in an effort to kind of establish that strict separation. But that is not currently the dominant belief among jurists in America. So we have to consider these other two variations on how to interpret that language. One of the most common ones that we'll see in some Supreme Court decisions is the neutrality version, where courts say that government must be neutral towards religion. It may not even endorse religion over non-religion. So they would look at laws that pertain to religion and try to determine whether the law is neutral enough. Is there any sort of endorsement or sponsorship or favoritism being given to a religious organization opposed to a secular organization or an atheist organization? So that's the neutrality interpretation. And the other one is the accommodation interpretation, where government can't coerce people to adopt a religious belief or practice, but they must accommodate religious beliefs and practices. And I'll explain that a little more in just a second. That may be the current trend right now in our U.S. Supreme Court, is to interpret laws through this sort of point of view of accommodation. keep in mind that when we're dealing with the First Amendment, there is no violation of it until a government employee or government entity takes some sort of action. Private citizens can infringe upon religious activities as much as they want. The First Amendment doesn't kick in until the government has taken some action, or a government actor, like an employee, has done that. Now we go to the free exercise clause. The language is or prohibiting the free exercise thereof. When we are dealing with the free exercise clause, we're talking about, we're most often talking about a law that applies generally, and just incidentally gets in the way of someone who is attempting to express their religious beliefs, practice their religion in some way. And our our understanding and interpretation of that free exercise clause has taken one of two different approaches. One approach was seen in a U.S. Supreme Court decision called Sherbert versus Verner, and that case actually happened in Spartanburg, South Carolina. It involved a law of general application, so this were laws regarding unemployment compensation. And a woman who worked at a textile, I think it was a textile mill in Spartanburg. She was a Seventh-day Adventist, which people who use that religious tradition believe that Saturday is the Sabbath. And so they don't work on the Sabbath. They're Saturday. They would not work on Saturdays. So she had declined to work on Saturdays at this plant, and she lost her job because she refused to work on a Saturday. So she goes to South Carolina Unemployment Commission and applies for unemployment compensation. And that commission looked to see, why are you unemployed? And they determined, well, she was unemployed because she refused to work. And on that basis, they denied her unemployment compensation. So she appealed and said, well, I've refused to work because if I worked, I would violate my religious belief that Saturday is the Sabbath. And on the Sabbath, you're not supposed to work according to my faith. And so we have a state actor. Okay, we had the South Carolina Unemployment Commission, who had taken an action that she believed violated the free exercise clause of the First Amendment. The U.S. Supreme Court looked at that and said, you know what? She's right. The state of South Carolina said, well, our reason is we aren't going to give unemployment compensation to people when they refuse to work. Well, okay, maybe that's fair, but you give unemployment compensation to people who refuse to work on Sundays, so you must do it as well for people who don't work on Saturdays and consider Saturday a Sabbath. That discrimination between people who observe a Sunday Sabbath versus people who observe a Saturday Sabbath, that was the problem. That was a discriminatory practice that showed South Carolina was favoring religions that believe in Sunday Sabbath and against religions that believe in a Saturday Sabbath. And because they could not justify that discrimination, their law violated the First Amendment. It was a violation of her free exercise rights. And in that decision, the Supreme Court said if a state passes a law that may apply generally, such as unemployment compensation laws, and that law of general application incidentally interferes with an individual's right to free exercise of their religion, then the state has an obligation to show a compelling interest for its law, and that this law is narrowly tailored to accomplish that compelling interest. That means that the law has to pose the least possible interference with the exercise of religion. And that's called now the Sherbert test, that state governments may apply when a person claims a violation of the free exercise clause. About 30 years later, though, another case came before the U.S. Supreme Court involving a very similar situation. In this case, it's Employment Division versus Smith. It was a law of general application, a law that made certain types of drugs considered as a controlled substance. Like, so it would be criminal to use, sell, or consume these certain drugs. One of those drugs was peyote, and that was a law that applied generally. So it wasn't specifically targeting any particular religious faith. There was a long list of controlled substances, marijuana, cocaine, heroin. We're talking about drug laws, generally, law of general application. But a couple of people who worked as drug treatment counselors were caught using peyote, and they were fired from their job as a result of that. They went to the unemployment office and asked for unemployment compensation, just as Mrs. Sherbert had. They were denied, just as Mrs. Sherbert was denied. And the reason they were denied is because they violated a law. They violated a criminal law. But they were Native Americans. And the Native American religious practices include the consumption of peyote. It's a substance, I believe, that is smoked. And so they argued that the state government's decision to deny them unemployment compensation violated their free expression of their religious faith. That decision got to the U.S. Supreme Court, and the Supreme Court did a total 180. They overruled the Sherbert case, or limited it. They didn't expressly overrule it. They limited its application, and they said, well, in this case, we're not discriminating against people who practice their religion one way versus another. There's no discrimination going on at all. Here, we just have criminal law. And these guys, they violated a criminal law. That applies to anybody. There's no discrimination going on the basis of their religion. And so in this case, the court said, you don't have to establish a compelling interest or show that it's narrowly tailored. If it incidentally interferes with a religious practice, oh well, there just was no evidence of any intentional discrimination going on behind the drug laws that were passed by that state government. But that particular decision, the Employment Division versus Smith decision, angered many, many people, and many members of Congress were upset by it. So they passed a law not too long after the Smith decision called the Religious Freedom Restoration Act. And that law said if any law of general application interferes with a person's genuinely held religious beliefs and practices, then the state has this difficult burden here from the Sherbert case that they must show a compelling interest for their law that is narrowly tailored and the least possible interference with the exercise of religion. This is a difficult test for a government to satisfy. And so this act of legislation was an effort to invalidate the Smith decision and take back the Sherbert decision. So here is Congress undoing what the U.S. Supreme Court had done legislatively, not by amending the Constitution, but legislatively invalidating a U.S. Supreme Court decision. Well, guess what the U.S. Supreme Court did? They held that the Religious Freedom Restoration Act was invalid. They nullified the act and said it violated the separation of powers and that the Employment Division versus Smith precedent was valid and would remain the law of the land. That was the job of the judiciary. However, this saga continues. Many state governments were also upset about the Smith decision, and states passed their own Religious Freedom Restoration Acts. And so, as it currently stands, in states, most states, particularly in the Southeast, they have a Religious Freedom Restoration Act, a version of that act of Congress that ultimately was invalidated. But at the state level, they still exist. And at the state level, many states have this Sherbert test for free exercise claims. As far as federal law goes, we're still dealing with the Smith decision, though. Okay. Where we stand now with religion is complicated, as you could probably see from that story about the two Sherbert case and the Smith case. Um, but the complications continue because the two clauses, the Establishment Clause and the Free Exercise Clause, often are both implicated in First Amendment challenges. And I'm going to give you an example here. This case called Kennedy versus Bremerton School District happened in 2022. And in this case, um, a he wasn't like a full-time staff. I think he was like maybe a volunteer assistant coach. He worked for the Bremerton School District though, but he was a football coach. And at the end of football games, he would go out into the middle of the field and pray. He never required any of the football players to come with them out there, but they chose to. And then sometimes, spectators, people who were there to watch the game would come and they would pray. And so you have this sort of group prayer going on the football field, which is owned by the high school and in turn owned by the school district, which is a state government organization in operation. So you had, a school employee um, leading students in prayer on school grounds shortly after a school activity. And so that frightened the school district. They were concerned that allowing this coach to lead these prayers would be seen as a violation of the Establishment Clause, as if the school was promoting a religious practice. So they told Mr. Kennedy, Coach Kennedy, you can't do this anymore. You can't pray on the field. Well, he got mad and didn't want to go along with that decision. And so he left his job or resigned under pressure or something like that. But he had a claim that he was wrongfully terminated or wrongfully prevented from praying. This was an expression of his faith to pray. And he claimed that the state government, the school district, was preventing him or interfering with his free exercise of religion. So there you go. Now you've got both the Establishment Clause and the Free Exercise Clause implicated in one specific case. So what's the Supreme Court going to do? Is this a violation of the Establishment Clause? Or are we dealing with a free exercise issue? How do you resolve it? How does a school or any government entity go about not endorsing a religion while also allowing their employees to practice their religion? And so in the end, the U.S. Supreme Court said simply allowing this coach of his own volition to go and pray on the field, not compelling, not coercing anybody else to join him, that was not a violation of the Establishment Clause. But when the school denied the coach the right to go and do this, they were interfering with his free exercise of religion. And so this is the court adopting the accommodation interpretation to the Establishment Clause by saying we must accommodate all individuals' right to exercise their religious faith. Even school employees have this right, and we can't interfere with that. And so they reversed the decision of the school district and said that he should be allowed to continue doing the prayer on the field as long as he's not coercing anybody to come with him. So that's a complication that we deal with quite often. Another complication is the fact that, as I said early on, American national government has never been strictly separated from religion. We've always had some overlap, some accommodations. Example being monuments, structures on government property, and God we trust on dollar bills. So there's always been some overlap. Religion has always played a role in American society. And so it's kind of up to the courts to decide whether this sort of blending of religion and government gets to the point of coercion. When it gets to the point of coercion, then we have a problem. We have a violation of the First Amendment. But it is a tricky, tricky situation. Um, Last, religious freedoms are not absolute. The government cannot tell you what to believe, but they can limit what you do. If your practice of religion hurts other people in some way or infringes on other people's rights, then it can be limited. And an example of that is polygamy. Um, in the late 1800s, the Mormon Church practiced polygamy, one man marrying more than one woman. And the U.S. Supreme Court, or in state passed a law that made it, I think it was actually a national law, made it illegal, polygamy illegal. A Mormon man challenged that law, and the Supreme Court upheld it and said, nope, there are limits to certain religious practices, one of them being polygamy. And they said that there are some laws that can place some restrictions on religious practices. They're very narrow. It really has to involve harm to other people before religious practice can be interfered with. It's going to be a very rare occurrence when a religious practice is prohibited, but it is possible. Free speech is next. Freedom of speech. We have to separate censorship with time, place, and manner restrictions. So time, place, and manner refers to when and where and how you are expressing yourself. States, it's usually municipalities, so cities, counties, may regulate public forums and say, we're open at this time, we close at this time. You can get a permit, apply for a permit, pay a small fee for a permit, and you'll get the right to speak for a limited number of hours at this location. Those types of regulations, as long as they are neutral about the content of what you're saying, viewpoint neutral, they're valid. If they're reasonable and viewpoint neutral, it's okay to have these time, place, and manner restrictions. What we can't do is censor the content. So what you're saying. We have to be neutral about what you're saying. However, it's always going to be a however. However, there are times in U.S. history where we have done just that. We have censored content. Notable example of that is in wartime, sedition. So sedition is speech that criticizes government or government activity. Early in American history, under the presidency of John Adams, our second president of the United States, the first Sedition Act was passed. It was a crime in the United States for an American citizen to print, utter, or publish any false, scandalous, or malicious writing about the government. That was the first Sedition Act of 1798. Didn't last long. Thomas Jefferson repealed or got Congress to repeal that Sedition Act. But in the 1990s, it came back. During the World War I era, we passed another law. I don't recall at the moment exactly what it was called, but it was targeting socialism and limiting the ability of citizens to protest America's involvement in World War I. It was limiting the ability of unions to organize themselves and present socialist economic policies. It was enforced. There are some examples of people who have been arrested and put in prison for violating the sedition acts of that time period. It kind of fell out of favor for a short period of time, but in the 1950s, they came back. But in the 1950s, we are now moving on and attacking communism. So there was something called the Smith Act that was passed in the 50s that made the expression of communist ideas illegal. And it was enforced for a short period of time. It is actually still on the books. It has not been repealed. The Smith Act is still there, but it lies dormant. It's not used anymore and probably would not be upheld if it were challenged in the courts. Just wanted you to know American history is complicated, and we uphold a lot of principles of freedom and liberty, particularly with the freedom of speech, but we do have a history of infringing upon it. But let's look at how we're dealing with it now. When can, if ever, when can a government censor speech? And it's very, very limited. When speech jeopardizes public safety, it can be censored. But courts are very careful with this. The speech has to incite imminent lawless action. So it's not just angry words. It is words that are intended to cause lawless activity, property destruction, physical harm, imminently, immediately. That has to be the intent of the words, is to physically harm or to threaten somebody physically, to cause property damage imminently. That those laws, that sort of censorship is upheld. I'm showing you a picture of a case that came from a case called Brandenburg versus Ohio. I'm not going to go into it in my lecture. I just wanted you to know hate speech is kind of a touchy subject. Hate speech is protected. It cannot be censored, hate speech alone. But if the hate speech incites imminent lawless action, if it harms someone in some way, it can be censored. So it has to go beyond just expression of a point of view. You can express a hatred point of view. You can express hate, express hatred. You just can't incite people to harm others. It's a narrow line, but when it is crossed, people can go to jail for harming someone with their words. But if it's just an expression of an opinion, even if it's a vulgar, offensive opinion, hate speech is protected by the First Amendment. It just has to, if it crosses that line towards inciting harm, lawless action, that's when you can be punished for it. School-sponsored speech is also a narrow situation where speech can be limited. So student speech in narrow circumstances can be limited. An example would be if a student's speech disrupts the learning process, if something a student says could be attributed to the school as if it was the school's belief, then it can be limited. And then like bullying online, you can restrict bullying speech. So there are limited times when students still have freedom of speech. Just because you walk into the doors of a school doesn't mean that a student loses their right to speak. But there are some certain situations where schools can censor the speech of students, some certain narrow circumstances when they can, such as when the speech disrupts the learning process or is some form of bullying. Those are just certain narrow examples. The picture I'm showing you is a picture of a young woman who worked for a school newspaper, and that's the Hazelwood decision. And in that case, the court said that the student newspaper, because it was part of a journalism class that was, it had a curriculum, that a teacher and the principal could set limits on what the students published in that newspaper. Third example, final example for this is obscenity. In certain narrow circumstances, speech that is obscene can be censored. But the definition of what is obscene is judged by community standards, local community standards. So there's no national definition of what is or is not obscene. It's determined by a jury and it's based on community norms and standards. Um, it's pretty limited, but it is possible to limit obscenity. It isn't just words that are protected by the First Amendment, also actions. Symbolic actions are protected as expressive behavior that can't be censored. An example being the burning of a flag. When that is done in protest of a political policy, that activity cannot be prosecuted as a crime. Here we move to press now, the freedom of the press. Um, the if there could ever be an absolutely protected freedom, it's this one, the freedom of the press. That is because the press now is and always has been the most effective check on the power of government. The press is there to create transparency, and the job of the press is to create transparency in the activities of government, to investigate what our government leaders are doing, and the right of the press to create that transparency is a check on government power that is essential to democracy. So protections for the press to publish what they want to publish is very, very high. And it's not absolutely protected, but it is as close as you're going to get. The big case on that is New York Times versus the United States involving the Pentagon Papers. This is a case that actually there's a Hollywood movie called The Post that's all about this particular U.S. Supreme Court decision where a man who had worked for a private contracting firm had been asked by the U.S. government to investigate the government's role and involvement in Vietnam. And as part of that investigation, this man and his work colleagues discovered that America had had troops in Vietnam long before the public knew about it, and that our national government had not disclosed to the public the extent to which we had been involved in Vietnam. But the government chose not to tell the public that. He believed, this particular one person believed that that was wrong. And so he contacted the Washington Post and the New York Times and offered to give them documents that he had gotten through this investigation. And the two newspapers wanted to publish these papers. They're called the Pentagon Papers because they came from a contracting firm that the Pentagon had hired to do this investigation. So the newspapers were getting ready to go to the presses to publish these Pentagon papers, and the president at the time, Richard Nixon, got a restraining order to try to stop the presses, to literally stop the presses, to stop the publication. That stopping of a publication is known as a prior restraint. To stop the presses is a prior restraint. So he attempted to do that, and the U.S. Supreme Court, in a rather long decision, explained, no, we will not allow you this prior restraint. That would be an infringement on the freedom of press. Um, there, um, there really wasn't anything in the papers that presented a risk to national security. Nixon tried to argue that it was a matter of national security because it did involve military actions. But these were military actions that had occurred even like up to 20 years ago. It wasn't some maneuvering that the military was going to do in the future. So it's not like they're disclosing troop movements or the locations of spies or anything currently happening. It was about past activities. It was an expose of sorts. And so there was no real justification, no real national emergency presented by this publication. So that was the reason why the prior restraint was held invalid and was not allowed. But it did leave us with this tiny little exception. There are tiny little times when we might interfere with the freedom of the press, when national security is truly implicated by, or truly placed at risk by a publication, okay, then maybe we can restrain the press. But it's really, really narrow. This particular case, the New York Times case, is relevant today. And we have an assignment in this learning module where you're going to talk about the current ban on, or proposed ban on TikTok. There's a U.S. Supreme Court decision that was released recently upholding a bipartisan law passed by Congress, signed by President Biden last summer, that was going to shut down TikTok's website in the U.S. The current administration has put a stay on the enforcement of that law. And I'm going to ask you to look at an article talking about this effort and comparing it to the New York Times versus United States decision, and just to kind of give your opinion on what you think our government ought to do with it. Last of the First Amendment protections is protections for assembly and petition, so political behavior. And there's not a whole lot to add to this subject. We're talking about the right of the people peaceably to assemble and to petition the government for a redress of grievances. This protection has been used by many political activists over the course of American history. It is strictly upheld. It is, our effort to check the power of government, similar to the freedom of the press. And the current interpretation and protections of it is very similar to speech, because it is a form of political speech to organize and petition the government. As long as the regulations on protests are viewpoint neutral and reasonable in their scope, they're upheld. But a government cannot use its like parade permits, protest permits, public forums. They can't restrict the usage of them on the basis of the content of what is being said. Any sort of regulations on public forums and roadways must be viewpoint neutral or content neutral. As long as they are content neutral and reasonable, they'll be upheld. Second Amendment, the right to bear arms. Historically, guns were part of everyday life. Historically, we can sum it up there. Until the Civil War, the right to own guns was a common law right, and if you had to own a gun particularly if you lived along the western frontier, it was almost by necessity. In the more rural parts of our country, there was no police force. You might have a U.S. Marshal, but that's a pretty wide jurisdiction. So we didn't have the same protections for public safety provided by our government, and it was up to individuals to protect themselves. So self-defense required the use of a gun in those circumstances, and that's why it was a common law right. Individuals had a right to own guns for hunting and for protection. Also, every state, we're talking about early American history, every state had a militia. And a militia, it consists of private citizens who are subject to being called up to serve their state government, to serve their state against threats, against political threats, even against threats of the federal government. In order to have a successful militia, one that could protect the interests of a state, the militia had to be armed. If these individual men who served in the militia didn't have a gun, they couldn't serve in the militia. The militia couldn't protect its state. So a well-regulated, meaning armed militia, being necessary to the security of a free state. That's what we're talking about. We're talking about the ability of states to defend themselves through their militia. That was necessary. That was needed in early American history. So you've got a need to have a gun for a militia, but you also have a need to have a gun for hunting and in some places for self-defense and protection of your family. In the well, we'll just say this, the Civil War area. Let's go back to there. The right to own guns, there were, well, let's go back further than that. Throughout American history, states have regulated gun ownership. They've never banned it outright, but they do place limitations on who can own a gun, when a gun can be carried around publicly. Those sorts of restrictions have always existed in one form or another. But it was during the Civil War and after the probably even before the Civil War, a lot of states used their gun regulations to restrict the liberties of African Americans and slaves to prevent them from owning guns. So even after slavery had been abolished, a lot of states passed laws prohibiting African Americans from owning guns. So, point being, states have always had regulations on gun ownership. That is nothing new. We've never had an absolute unlimited right to bear arms in any state. We've always, I don't want to say any, most states, there have been regulations on gun ownership and use. The federal government's effort to place any restriction on gun ownership and use didn't really come until the early 1900s when the federal government was trying to crack down on the mafia, the mob of all things, on organized crime. That's the reason we started having federal gun laws. We were trying to tackle the Jimmy Hoffas of the world. And so it wasn't until then that you saw any sort of federal regulation on gun ownership. But those state regulations and then these federal regulations, they kind of come on the stage after the fact. So we get into the late 1990s where the courts are called to actually look at what does this mean? To what extent can any federal or state regulation infringe on the right to bear arms? And it is complicated by the way the amendment is written with this preface clause. The prefatory language about the militia kind of makes it seem like this clause is limiting this clause, that this right to bear arm really is just in the context of a well-regulated militia. So, in that sense, this is a state's right, not an individual right. It's the state's right to arm their militia, not an individual's right to keep and bear arms. It doesn't say the individual's right to keep and bear arms, it's the right of the people. So what does that mean? Does it mean the people acting as a state or the people acting individually? So that's the conflict. Currently, our federal courts have interpreted this to mean an individual right. It is a right of the individual to keep and bear arms. That choice to interpret it that way came about in 2008 with the Heller decision, District of Columbia versus Heller. That decision has been elaborated on very, very recently, in the past, let's say 3 or 4 years. The U.S. Supreme Court has twice looked at state regulations on the use and possession of guns, and the courts are going to uphold those regulations where they find, and this is language straight out of the Bruen case, historical analog. So what is a historical analog? What they're doing is looking into the past. Have states in the past had these types of regulations? If yes, well, then this current regulation is valid under the Second Amendment. That's what we mean. So the current interpretation is states can regulate gun ownership and use provided the regulation has a historical analog. Okay, Third Amendment, not a whole lot to say about that because we don't use it very much. Let me just remind you, why do we have the Bill of Rights? Why did we choose these particular rights to protect opposed to others? Why did we enumerate these ones? Well, we did that because these are the ones that the British government was notorious for infringing upon. That's why we chose these specific rights to enumerate, because they were the ones we cared about at the time. In the late 1700s, 1760s, 1770s, the British government was notorious for requiring British subjects to give quarter to their soldiers. British soldiers could come into a private home and stay there, live there, sleep there, eat the food there, use the livestock there, or take it. Take the livestock, take the crops with them as they march across the battlefield fighting against the French and the Indians. So this quartering that the British subjects were required to give to soldiers was not compensated. The British government never paid them back for the loss of their property. And that made them mad. And that was one of the reasons we declared our independence and fought the Revolutionary War. And it is the reason why we have a Third Amendment. It was a grievance against King George listed in the Declaration of Independence. We still look at the Third Amendment today as a foundation for the common law right of privacy. So the Third Amendment then becomes a foundation for what we would call an unenumerated privacy right. So something we'll come back to when I talk about the right to privacy and unenumerated civil liberties. We see this in several amendments, this recognition that a man's home is his castle, or a woman's home is her castle. This privacy, the right not to have your private property intruded upon by the government, is founded in several amendments, and this is just one of them. That's why the Third Amendment is actually still relevant today. See that kind of also in the Fourth Amendment as well. But to give you a little bit of a backdrop, the next three amendments, Fourth, Fifth, Sixth, and even the Eighth Amendment, in each of these amendments, what we're dealing with are civil liberties that are affected by law enforcement. So this is the state doing things in an effort to keep the community safe, to protect the public from criminals, but it's running up against the rights of individuals to be free. And so we have 3 or 4 amendments that are going to require courts to strike a balance between the ability of the government to protect the public, maintain some community safety and order, against the right of the individual to be free from government intrusion. So with the Fourth Amendment, we're dealing with search and seizure laws. So these are the laws that govern when law enforcement can come and take your property, take your home even, or take you to jail, arrest you. Their Fourth Amendment has 2 clauses, and the first is the reasonableness clause, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. That's called the reasonableness clause. So any search and seizure must be reasonable. Well, what the heck does reasonable mean? Well, that depends on the circumstances. The facts of the case will determine whether law enforcement has acted reasonably. But law enforcement has learned a lot of lessons through being challenged by individuals on the basis of the Fourth Amendment, and developed protocols and policies for law enforcement to follow, just learning from experience, from the case law, what's reasonable and what's not reasonable. There's also a warrant clause, the second one. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that warrant clause requires that warrants must be based on probable cause. So what is probable cause? Probable cause means a reasonable belief that a crime has been committed or evidence will be found. So that's what is a warrant must be supported by that reasonable belief that a crime has been committed or evidence will be found. So you must have probable cause supporting a warrant. That probable cause must be established by an oath, sworn testimony, like an affidavit. And the warrant itself has to be very specific about its scope. It can't be open-ended, no general warrants. You must have details of the scope of the search or the specific person who's going to be arrested. There are a gazillion exceptions to the warrant requirement. But in a general sense, if there are exigent circumstances, a warrant does not have to be gotten. Now, there must always be probable cause, so don't be confused. Probable cause is absolutely required before an arrest. The exception is just for stopping the pursuit and going to a judge and getting a warrant. That delay in seizure can present a risk of safety, loss of evidence, suspect getting away from the scene of a crime. So you don't always have to stop and go get a warrant, but you must stop, or you must have probable cause. So probable cause always must exist, even if there are some exceptions to actually going and getting a warrant. If you violate the Fourth Amendment, I've got ahead of myself, sorry. First, we must look at, when does the Fourth Amendment apply? It's only going to apply when a person has a reasonable expectation of privacy. Now, it's obvious that you have a reasonable expectation of privacy over your person. So when we're looking at this, we're not looking at the human body. That's private. We know that. But now look at property. When can property be invaded or seized? That protection of the Fourth Amendment isn't going to apply unless that property is private, truly private. So, for example, if you have a piece of paper and that piece of paper is some sort of admission of guilt, like it's the smoking gun in a case, and you've got it in your possession and you're holding it, and you're keeping it, in a bag or your backpack or in your purse or in your home. The government must have a warrant to go and seize that from you. But if you take that paper and you wad it up and you toss it in a trash can on the side of the road, you cannot reasonably expect it to remain private. Anybody could walk up and pull that paper out of that trash can. So the privacy that surrounds the property is lost when you toss it away, when you toss it in a trash can. So you no longer have a reasonable expectation of privacy. When you don't have that reasonable expectation of privacy, the Fourth Amendment does not protect against invasion. So you have to keep that in mind, or government law enforcement officers should also keep that in mind. Fourth Amendment doesn't apply unless the subject of the search is reasonably considered private. Now, what about violations? Oh, the Katz case established that precedent for having a reasonable expectation of privacy over the subject of the search. That came from the Katz decision. What happens when you violate the Fourth Amendment? The Fourth Amendment is violated, or when it is violated, the evidence that is obtained as a result of that violation is excluded from trial for the purpose of establishing guilt. So if you violate a suspect's Fourth Amendment right, when you seized evidence, the evidence you seized in violation of the Fourth Amendment can't be used to establish that suspect's guilt at trial. You can use it to impeach the defendant. If he lies about something on the stand, you can use this evidence against him to establish the fact that he's lying, but you can't use it to establish his guilt. So that's what the exclusionary rule is. The exclusion of evidence that has been illegally obtained, not using it to establish the guilt of the defendant. I didn't tell you the story of the Katz case. It is pretty important. It involved a wiretap that was placed on a telephone booth. And this is like the old-fashioned telephone booths, like the kind of the box things that you might see on the side of on a sidewalk somewhere in a park maybe, and a landline, rotary dial phone that you would pick up, you put a quarter in it, you make a call. So this guy, Mr. Katz, he was going in a public phone booth, putting his dime in, his quarter in, calling up and placing bets on horse races. So he was using it for gambling, which was illegal in his state. And so the U.S. government put a wiretap on the phone booth, overheard his conversation with his bookie, and used that recorded conversation to prosecute him for violating the gambling laws. Mr. Katz said that invaded his privacy. The government said, well, no, it didn't. This is a public phone booth. There's no expectation of privacy on a public place. Well, the U.S. Supreme Court said, no, the privacy is the conversation. He went inside a confined space to have a private conversation. He had a reasonable expectation of privacy over what he was saying. And so the court's explaining to us here, privacy is not about location, it is a personal right. What did the person believe about what he was saying or about the physical, tangible property in his possession? If he had a reasonable expectation of privacy surrounding this, in this case, the conversation, but it could be a piece of evidence, tangible evidence, or it could be, your person, your body, of course, is private. So that case is known for saying that this right against unreasonable searches and seizures is an individual right. It's not just about location. The exclusionary rule was the subject of the case Mapp versus Ohio. I'm not going to go into that one in particular. I'm just explaining why that case name is on the slide here. In the Mapp case, the Supreme Court said that the exclusionary rule would apply even in state courts, that illegally obtained evidence cannot be used to establish the guilt of a defendant, even in state court cases. This is an example of selective incorporation, where the Supreme Court has selected this particular rule, this protection for against unreasonable searches and seizures, incorporated it through the language of the 14th Amendment, and extended it to states. Next amendment. Oh, the exclusionary rule also has exceptions. Like I said, you can use illegally obtained evidence to impeach a defendant, to prove the defendant is lying. If there's an exception for when illegally obtained evidence would have been discovered regardless. It's called the inevitable discovery exception. So that in those situations, the exclusionary rule won't apply. Those are just some examples. There are exceptions to the exclusionary rule, just like there are exceptions to the warrant requirement. Fifth Amendment. Now we move on. Fifth Amendment. Again, we're balancing the government's interest in protecting public safety, but we're balancing it against an individual's right, particularly the rights of the accused. That's what we're moving into now. The Fifth Amendment protects the right to have a grand jury. So it says, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So a grand jury, we are not talking about the 12 people who determine guilt or innocence. That's called a petit jury. A grand jury is a different group of people. It's not the people who ultimately decide guilt or innocence. Rather, these are the people who decide whether or not to indict someone, to charge someone with a crime. So this is a control on abuses of power by the prosecutor to prevent a prosecutor from arresting just anybody. A grand jury would be required in federal cases, only in federal cases, and they are there to determine whether or not the U.S. government can indict or charge a person with a criminal offense. So again, it only applies in the federal courts. A lot of states use grand juries as well, but they don't have to. This is not a liberty that has been selectively incorporated and applied to the state courts. It still only applies in the federal court. Okay, next one. Double jeopardy. It says here, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. That is the double jeopardy clause. It prevents a government from rearresting someone. So let's say they arrest someone, prosecute them, the jury acquits them, finds not guilty, person goes free. The government can't maybe go back and arrest them again and try again with a different jury. That would be a violation of double jeopardy. So that's where that protection comes from. This one includes self-incrimination, nor shall be compelled in any criminal case to be a witness against himself. So this is a testimonial protection. So you can't require someone to say something. That is the source of the right to remain silent. So we know that from Miranda rights. I bet every one of y'all could recite what the Miranda rights are. Those rights were laid out in Miranda versus Arizona. That's a particular Supreme Court case where a man was arrested for rape, held by the police in custody for hours, interrogated for hours under intense and probably terrifying circumstances. He was never told that he had the right to remain silent. He was never told that he had the right to an attorney. They just kept interrogating him until ultimately he confessed to the rape. They used that confession to convict him, sentence him to prison, and he appealed. And the Supreme Court said, you, government, speaking to the government, had an obligation to advise Mr. Miranda that he had these rights to counsel, that he had the right to remain silent. You can't say that he waived those rights just because he spoke. He ultimately spoke after this long interrogation, and he had no idea he had the right to remain silent or the right to insist on an attorney. So he couldn't have waived a right he wasn't aware of. So that was the argument. What the U.S. Supreme Court said, you can't establish a waiver of a right that the person doesn't know they have to begin with. And so out of that decision came the law enforcement's obligation to tell people their rights at the moment of their arrest. You have the right to remain silent. You have the right to an attorney. That came from the Miranda decision and is all drawn out of this right to not incriminate yourself that is protected in state courts by the Fifth Amendment. It has been selected. Going forward, next clause, nor be deprived of life, liberty, or property without due process of law. That is the source of due process protection. It is the Fifth Amendment. This only applies to the federal government. And as I mentioned earlier, due process means procedural due process. So procedural rights, like the right to have an attorney present. It also provides for substantive rights, such as the right to marry, the right of, well, there are a variety of rights that are substantive that we'll get into later when we're talking about unenumerated liberties. But the source of that protection would come from the Fifth Amendment's due process clause when it's the federal government taking action, the 14th Amendment's due process clause when we're dealing with the state government infringing on due process rights. The last bit, nor shall private property be taken for public use without just compensation. That is called the takings clause. And anytime the government takes private property for public use, they have to pay for it. They have to pay market value for it. That's what just compensation means. So that protection it's really private property ownership. Protection for private property ownership is provided in the Fifth Amendment. Sixth Amendment, moving along. Again, this is a balancing act. The government's interest to protect the public with an individual, and in particular, criminal defendant's right to defend himself at trial. It's a laundry list of rights, including the right to a speedy public trial and an impartial jury. Okay, speedy, not defined. We don't know what speedy means. It can mean a variety of things. What courts are looking at is, has the court or the prosecution intentionally delayed the trial, unfairly or unreasonably delayed it, then it could be a violation of the Sixth Amendment's right to a speedy trial. Public trial, that requires judges to open up open up the courtroom to the press or to the public. The public and the press have a right to attend and watch trials occur. That is a part of government transparency and protection for really all individuals' right to know, the right to know what your government's doing. So that comes from the public trial. There are very narrow situations when a judge could close the courtroom, but this Sixth Amendment means judges have to most of the time keep them open in public. Last, impartial jury. So an impartial jury is a jury who has not already made up their mind about the guilt or innocence of the defendant. That's what it means to be impartial. Doesn't mean they've never heard of it. It just means they haven't drawn a conclusion about it yet. So you may hear it referred to as, oh, I have the right to a jury of my peers. No, you don't. It doesn't say jury of your peers. Nowhere in the Constitution does not say that. It says you have the right to an impartial jury. So they aren't looking at whether the jury are your peers. It just means that the jury comes from your community. It does say that by an impartial jury of the state and district wherein the crime shall have been committed. Okay, so it will be jurors from the community where the crime occurred that have not already formed an opinion about the guilt or innocence of the defendant. That's what we mean. Next, the right to be informed. The right to be informed of the nature of the case and cause of the accusation. So that is interpreted as the right to be informed of the charges brought against you as a criminal defendant. There are several times in the scope of a criminal prosecution where the defendant must be brought before the judge. I think the requirement now is like 24 or 48 hours. Someone who's been arrested must be brought before a judge very quickly and be informed of the charges against them. There has to be a written charge sheet that informs the defendant of the specific crimes he's being accused of. Then later the court will, make sure that the defendant is aware of the charges brought before him before a trial begins. The next one, the accused shall enjoy the right to be confronted with the witnesses against him and to have compulsory process for obtaining witnesses in his favor. So this is the right to cross-examine the prosecution's witnesses, as well as the right to subpoena and call witnesses on behalf of the defendant. The last, the right to have the assistance of counsel for his defense. So this is the right to an attorney, or the right to counsel. The right to counsel is something that has evolved over history, has not always had the same meaning. If you look at the words here for a second, the accused shall enjoy the right to have counsel. So it does not say it is not an obvious obligation of the government to provide counsel. It doesn't say that the accused shall enjoy the right to have counsel provided for them. It does not say that. So early on in history, all this meant is that law enforcement could not get in the way of a defendant hiring a private attorney to represent him. And that's all it was. They couldn't stop someone from hiring an attorney. That evolved, that changed over time. And that change has occurred in fits and starts gradually. Several, many Supreme Court decisions have interpreted that to mean something different, to the point that now it means any time that a defendant is being charged with a crime for which he could be put in prison for 6 months or more, he has the right to have an attorney provided for him at government expense. So that's, we've come a long way from what the right originally meant, but it's because we saw abuses of prosecutorial power, where indigent defendants, oftentimes it was African American defendants, were being unfairly arrested and charged and prosecuted and tried without adequate counsel. They couldn't afford to hire an attorney, or if the state provided an attorney for them, the attorney was terrible, didn't do their job right, didn't give real representation to the criminal defendant. So this is a very necessary adaptation of what this language means to respond to the reality that in the past governments have, our law enforcement has abused its prosecutorial power. So we have this safeguard now that indigent defendants have the right to have an attorney provided for them at state expense to ensure to ensure the integrity of the judicial system, that it is what it says it is, equal justice under law for all people. That doesn't have any meaning if people aren't able to truly defend themselves and assert their civil liberties. That protection isn't real if they don't have an attorney's assistance. So it was a necessary evolution. Next. Gideon versus Wainwright. Sorry, I forget that I have case names in here. Is the source of the most recent interpretation of what it means to have that right to have an attorney provided for you whenever you're charged with a crime that bears a sentence of 6 months or more in jail. Seventh Amendment. Not much to say. This is the extension of the right to a jury trial to civil cases. So the original Constitution gives the right to a jury in criminal cases. The Seventh Amendment takes that a step further and says people have a right to a jury in civil cases, so lawsuits over money, individuals suing each other over money. Not talking about prosecutions. These are private people, private citizens suing each other. The the Seventh Amendment right to a jury in a civil case has not been selected by the courts and incorporated into the 14th Amendment's due process protection. So it is only guaranteed in federal cases that are brought in the federal court system. However, most states have the same requirement, so that in reality, as it plays out, even though the Seventh Amendment doesn't require it, state law is still going to include the right to a jury even in civil disputes. In most cases, not in every case, but in most cases, that's true. Eighth Amendment. This amendment pertains to punishment and bail. So overall, what this is looking at is proportionality, fairness, fundamental fairness. Let's read it. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So it's three things now that it's covering. It's covering bails, so excessive bail, that would be unproportional bail settings. If you don't already know, bail is the amount of money that a defendant can pay in order to be released from police custody pending trial. Bail is often set in at the arraignment early in the criminal prosecution, and it has to appropriately match the offense or what the defendant is being charged with. So it cannot be excessive or unfair, unreasonable. It also applies to fines. So you can't impose a gazillion-dollar fine for a very minor offense. There must be some proportionality in fines. Punishment, not just talking about execution or even talking about jail sentences. Punishment must fit the crime. It's got to be proportional. Now we know this amendment, particularly because of the language about cruel and unusual punishment and thinking about the death penalty. And there's a lot of debate currently in society about whether the death penalty is just and fair. The U.S. Supreme Court has spoken on that several times. There's some complicated decisions out there interpreting the Eighth Amendment. To my knowledge, there is no Supreme Court case that defines a specific form of execution as being inherently cruel and unusual. So as far as the choice of what type or manner of execution goes, that's kind of an open question. There's a variety of different ways that states might execute a criminal defendant. The notorious one you might have seen in the media recently is firing squad. South Carolina provides criminal convicts with the choice to choose a firing squad in place of in place of lethal injection. But as far as I know, there is no Supreme Court case that actually defines a specific type of execution as inherently cruel and unusual. Um, the the determination of whether to impose the death penalty is also going to involve what is cruel and unusual. So when can death be the sentence? And there are some Supreme Court decisions that are pretty definitive about that. One in particular is Roper versus Simmons, where the Supreme Court has held that defendants who commit their crime, it would have to be murder, commit murder while juveniles. So if they are 17 or younger, when they commit the murder, they cannot be sentenced to death. That was a Supreme Court holding. There's a similar one involving mentally disabled people. If a criminal defendant is mentally disabled at the time he committed the offense, then he cannot be sentenced to death. We're not talking about criminal insanity. Not talking about that. That's a different issue. I'm talking about um, like underdeveloped, mentally underdeveloped. I'm trying to think of some examples of diseases of the mind, that make people slow, unable to understand the consequences of their actions. So maybe someone with Down syndrome, that would be an example. They're not criminally insane, but they just don't have the mental capacity to make judgments about right and wrong. So they can't be held to the same level of culpability. So that's another time where the Supreme Court has held that death cannot be the sentence. So there are a few cases that really give some definition to when death can be imposed. Generally, though, this language, cruel and unusual, is going to be determined, I should have put quotation marks around this, evolving standards of decency. That came from the U.S. Supreme Court decision, Roper versus Simmons. So what we consider to be cruel and unusual now might not be considered cruel and unusual when these words were written in 1789. So the court is allowing society to adapt its interpretation of what is cruel and unusual. What we think is decent or indecent now would not be the same in the past. So we look at modern standards of what is cruel and unusual. Ninth Amendment is your protection for unenumerated rights here. It says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. Here, the Congress is saying that the Bill of Rights is not the end of it. There are other common law rights that we as a society consider inalienable or natural rights, something that is inherent in the notion of freedom. Those rights exist, they will be protected. Just because we didn't enumerate them in the Constitution doesn't mean that they are less important or that they don't exist at all. It just means they just weren't enumerated. They still exist, they'll still receive protection, they just haven't been listed. So we're acknowledging that is a fact. The drafters, the founders of our country never intended these first 8 amendments to be the end of the story on what rights exist and what rights don't exist. There are many other rights and liberties that exist that all individuals have that will be protected by our courts. They'll be recognized, identified, and protected. Those will be the subject of my lecture on unenumerated civil liberties. Example, the right to privacy. The 10th Amendment, the last of the Bill of Rights here, actually doesn't provide any protection for civil liberties at all. It's really just reflecting a couple of constitutional principles that we learned about in the very first learning module, limited government and federalism. It says, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. So what we're saying here is we have delegated specific powers to the U.S. government, and the U.S. government is limited to the exercise of those powers. All other powers, if they haven't been prohibited to the states, are reserved to the states. That's federalism, the division or balance of power between the national government and the state government. That's limited government. We've delegated specific powers to the United States by the Constitution. Keep in mind the supremacy clause, though. I don't want you to forget. The Supremacy Clause says that all laws, including the Constitution and federal laws passed under the authority of the Constitution, are the supreme law of the land. So, what does that mean as far as civil liberties go? States can extend protection of civil liberties further than the U.S. Supreme Court has. So states can offer greater protection than the U.S. Supreme Court has. But once the Supreme Court rules on a liberty's protection, that ruling will preempt any state law on the same subject matter. So states can't restrict civil liberties. They can only enlarge them. I hope that makes sense. States can enlarge protections for civil liberties. They cannot restrict or narrow them down. So it kind of lays a threshold of what states must require. But they can do better than that. They can offer greater protection, but not lesser protection. All right, I'm going to stop there. As far as enumerated powers goes, that is your lecture. I'll pick up with the next learning module with talking about unenumerated civil liberties, and I'll also include civil rights at that time.